Hello, all. My name is Cassandra Jenicky, and I am your instructor for business law at Columbia College. Today, we're ending our whole class, with a conversation about shareholder rights and securities. So let's get started. So we talked last time we met about corporate formation, how corporations are managed, and we talked briefly about shareholders. Shareholders are the owners of our corporations, right? And so how do you become an owner of a corporation? Well, that starts with either purchasing a stock or a bond in a corporation. So let's talk about that for a moment. So the nature of stock, when we talk about capital and capital stock, corporations sell stock to raise capital, money. Okay. So capital are the net assets of a corporation: cash, property, widgets. Okay. That's capital. Capital stock is the value received by the corporation for its outstanding stock. Value meaning what is the cost of it on the publicly traded or private market to own a piece of a corporation. Stock is valued a couple of different ways. So par value is just the price that is assigned to the stock at its issuance. Book value is based on the company's net assets. So if you were to divide its net assets by how many shares of stock have been issued, that's your book value. But then your market value, which I think is the one that we all think about very typically, is the price of the stock on the open market if it were being traded. So your certificate of stock is evidence of your ownership. Some states will allow for uncertified shares to be issued, but after our very lengthy conversations about contracts, I think you and I both know that you should always have some written evidence of a financial transaction. So you're going to want to have a certified stock. Now, different kinds of stock. So stock is classified by preference, and preference specifically references the concepts of dividends and when and how they're paid. So common stock is going to be your ordinary stock. You are going to be entitled to have a vote. You are going to be entitled to receive dividends, and you are going to be able to participate in the distribution of capital upon dissolution of the corporation. Preferred stock is non-voting, but you have priority over common stockholders regarding dividend and capital distribution. So some further subsets of preferred stock include cumulative preferred, participating preferred. Preferred stock, you don't get to vote, but you do get more money when dividends are paid and when the corporation is being dissolved. Shares exist for the life of the corporation, so they never die. Fractional shares can be issued, right? So they're going to issue a fourth of a share, half a share, things of that nature can be issued. Rarer, but for some of those pricier stocks, it's a good way to go. Now, compare corporate stock to bonds. So bonds constitute a long-term loan that obligates the company to pay back the principal and interest on the date of maturity. So whereas stock is you paying for the pleasure of being an owner of the company, a bond makes you a lender. Okay, you don't own anything in the corporation, but the corporation and you have a contractual obligation whereby you give them money now, and then they give you back that money plus some once the bond matures. You definitely you don't want to be a debenture bond, because you then become an unsecured creditor. Nobody wants that. And so you want to be a registered bond, meaning that you are a registered liability recognized on the corporation's books, because then you are a secured lender. Very important. So when we talk about bonds and the terms and control related to the bonds, your contractual agreement is going to be set forth in the bond indenturement, also called a deed agreement. Okay. So again, written, very important. Bondholders' interests are represented by an indenture trustee who is responsible for ensuring that the corporation complies with the bond indenture. It's typically going to be a bank. They're going to be monitoring to make sure that once your bond hits maturity, you're getting paid back and you're getting your interest. How do you become an owner of a corporation? Well, it's quite fancy sometimes and then quite unfancy other times. So you can acquire shares in a corporation either from the corporation itself or from existing shareholders. So let's talk about both of those. When you're getting it from the corporation, we typically call it a subscription. Okay. So if you are subscribing to acquire shares and to be an owner of a corporation prior to it incorporating, in some states, you automatically become an owner. Like you just ask for it and you get it. Other states, which is the state that I would prefer to operate in, your offer of subscription must be accepted by the corporation. Okay. Now, when you are subscribing for shares after the corporation is incorporated, then the corporation must accept your offer, because at that point they are privately or publicly available shares. So you have to let people buy. So subscription is when you're getting it from the corporation itself. Transfer is when you're getting it from a already existing shareholder. Okay. Restrictions can be placed on transfer of shares. So your certificate of ownership of your stock will include any restrictions on the transfer of that share. You can absolutely, partially, or utilize as collateral your shares in a corporation. But those restrictions that I mentioned earlier are valid unless they're unreasonable and unless they infringe on trade. So don't do that. So how do you transfer? Well, you have to, or what is the effective transfer? Sorry, not how do you do it. How you do it is literally like handing it over, exchanging, right? So validity of transfer, you have to satisfy the requirements of any property transfer. So you have to, agree. You have to reach the contractual agreement. You have to transmit proof of ownership, things of that nature. Money has to exchange hands, right? You have to complete the bilateral contract. Shares of corporations can be negotiable instruments. So as we talked about during that section, you're going to be subject to fewer defenses to payment. Okay. They can be utilized as collateral for loans because they have value, right, as a negotiable instrument. And the corporation will provide dividends or treat the person on their books as the owner. So it'll be really, really important for you to make sure that the corporation knows that you are the new owner, right? Because you want to make sure that you are the owner of record on the day that they decide to issue dividends, on the day that they decide to dissolve the corporation and you get to participate in capital dissolution, right? Make sure your names are on the books. So as an owner, you are entitled to a certificate of stocks. You can transfer shares. Okay, unless we talked about those restrictions. You have the right to vote. So common shareholders of record, again, so you want to be on the book. And you can't be a preferred shareholder, right? Because preferred shareholders get more money earlier, typically, versus your common shareholders who get to vote. So it's like, do you want the more money? Do you want to vote? It depends. The number of votes you get, so there's straight voting, which gives each shareholder one vote on each matter, regardless of how many shares you own. Okay. Under a cumulative voting plan, each shareholder has as many votes as the number of shares owned, multiplied by the number of directors being elected. So if you're electing 5 directors and you own 25 shares, so each shareholder, you take your number of shares, 25, multiplied by 5 directors being elected. So you get 100 votes, 100 votes. You can have somebody vote for you. So it's voting by proxy. And sometimes there are voting agreements and trusts where folks will create a voting trust so that their votes are transferred to the trustee for that person to vote for them. Okay. So a nifty right for shareholders. So let's say, for example, you own 30% of a corporation and the corporation and you aren't getting along very well. And so the corporation decides to issue new stock. So to try and change the percentage of your ownership, they don't get to do that. You have the right to subscribe to any newly issued shares at the same percentage that you currently own. So if they, if they have 100 stock, 100 shares, and you own 30 of them, and they issue another 100 shares, you have the right to subscribe to 30 of those new shares to maintain your 30% ownership in the corporation. And you have basically the right of first refusal, must offer it to you. You can reject it, but they have to offer it to you. You also, as a shareholder, have the right to inspect the books. That right is typically limited by statute. And so you have to do it in good faith. You have to do it for proper motives. Typically, there have to be a certain number of shareholders that want to review the books. There's no specific requirement for the form of the book, so good luck looking at some of these things. And financial statements have to be furnished annually to all shareholders. Now, I mentioned the word prior, but didn't explain it at that time. So dividends. Dividends are basically the benefit to owning shares of stock, right? So there are supposed to be funds available for let's back up. Not every corporation issues dividends, and those that are able to issue dividends don't issue them all the time. So dividends are basically money that you are supposed to be earning and given when a corporation has a profit. So funds available for declaration of dividends, those must come from earned surplus or retained earnings in order to declare dividends. There is an exception for wasting asset corporations. So for example, oil corporations, they get to issue dividends whenever they'd like, out of a profit, mostly because it's a finite resource, right? They can pay it out of current profits. These are dividends are issued at the discretion of our directors. They usually come in the form of money, but sometimes can also come in the form of stock. As I mentioned earlier, you want to make sure that you are on the books of the corporation as soon as you buy stock in that corporation, because dividends are declared as of a declaration date and payable to shareholders as of the record date. The payment date then follows. So the owner on the record date is going to be the one that receives the dividend, even if the shares are transferred before the payment is issued. Okay. So make sure you're on the books. As I mentioned earlier, shareholders are entitled to capital distribution, right? So upon dissolution, divorce of the corporation, shareholders are entitled to receive any balance of corporate assets after all your creditors are paid. So your shareholders get paid out last, and that assumes, for the sake of conversation, that there's anything to pay them with. And then preferred stock, right, gets preference in a capital distribution. They don't get to vote, though. Again, a balance. Shareholders can bring a derivative action against the corporation on behalf of the stockholders. If they initiate a special litigation through a derivative action, then the corporation will create a special litigation committee to decide what to do on the suit. That special litigation committee can demand that an entire board be excused. It's basically their way of making sure that any decision-making related to the litigation is not made by the board of directors that is maybe being accused of wrongdoing. So it eliminates the opportunity for a conflict of interest. As I mentioned, I think the last time that we met, the liability of our shareholders is generally limited, and that's appropriate because we want to make sure, gosh, I keep missing updating the one ofs. Sorry, guys. Because that is the benefit of a corporate structure, right? Is making sure that your owners have limited liability. But there are certain instances where it is appropriate, nay required, that the courts ignore the corporate structure because the shareholders have engaged in behavior that requires that they be held personally liable beyond the corporation's function and structure. So when we ignore the corporate entity, That is called piercing the corporate veil. The court will disregard the corporate entity and hold individual shareholders liable where there was a failure to maintain adequate records and a commingling of personal and corporate assets, where the corporation was grossly inadequately, I have to get the adjective right, where capitalization of the corporation was grossly inadequate, where the shareholders participated in a diversion of corporate funds or assets to the personal entity. The corporation was formed to avoid existing obligations or to commit fraud. Or a court may say, you know what, injustice is going to follow if we don't pierce the corporate veil and hold the shareholders liable. Some other options includes the alter ego theory, where an individual controls a corporation to the extent that the separate personalities of the corporation and the individual no longer exist. So if I incorporated Cassandra Jenneke Incorporated, and I am the sole person that works for that corporation, I'm the only shareholder, I'm the CEO and everything else down from there, and I'm also its only employee, chances are the court is going to find that the corporate entity is just an alter ego for who I am as a person, and then will hold me personally liable. If you, as a shareholder, obtain an advantage by virtue of the corporation's existing, then courts will not go behind the corporate veil simply because the corporation was formed for a beneficial purpose for the shareholders. That's the whole purpose of that business formation, right? Of the business organization itself. You do it for the tax advantages, you do it for the limited liability. That is all okay. You just can't do it to commit fraud, avoid fraud, or while, in the corporate form, commit those types of offenses. Some other exceptions to limited liability: wage claims. They'll go and rake at your shareholders for that. Unpaid subscriptions will allow creditors to go after stockholders for the balance. And then any dividends that were paid without authority, so unauthorized dividend issuances, shareholders can be sued and clawed back those dividends in order to pay out creditors, things of that nature, particularly when dividends are paid out of capital rather than profit. So our last little note about shareholders, the professional corporation. So we talked a little bit about these earlier when we discussed the different types of corporations, but where the act of a shareholder, who is one of the professionals, remember, creates liability, then they usually require that share for the ownership be limited to duly licensed professionals, right? They have to be a member of the trade. They must be one of the professionals that we're talking about. Malpractice, as I mentioned before, not affected by this. So an individual, even though they are a member, a shareholder of a professional corporation, will be held liable for their own malpractice and the malpractice of those that they supervise. So that is how shareholders own, manage, are liable for the acts of the corporations that they are owners of. The last section that I just want to talk to you about is how we regulate the things that they own, right? So stocks. So three big ones to really talk about. So the Securities Act of 1933 is the first one. So we have the history of federal regulations of our capital markets really to thank for most of our securities statutory regulations. So we have the 1929 crash and the Depression, realized that we needed to regulate the market. You have the 1980s market abuses that really gave us pause once again. The savings and loan crisis and volatility of the early 90s. You have shareholder class action suits, abuses by shareholders. And then of course you have the early 2000s where you had Enron and then everything that came after Enron. When we look at that historical framework, we come up with kind of some definitions and the overview of the 1933 Securities Act, which has been amended over time, which is why the historical framework is important to understand the amendments that come later. So a security, which was never defined before this day, is an investment in a common enterprise with profits to come from the efforts of others. So funnily enough, this had to include conversations about alcohol because of prohibition, and then farmers, because they've got a great lobby. So some things that are exempt from the Securities Act registration requirements. So intra-state offerings, so those that stay within a state, those are regulated by state law rather than federal law. And then all of these other different types of exemptions. One that I think is really interesting as we move forward now, right, is the crowdfunding concept. So crowdfunding, you know, where you are online and you see this really great thing that you hope somebody invents, and oh, somebody is inventing it, and oh, they just need some more money so that they can finish the invention, right? Those types of crowdfunding, that's exempt. Those don't have to be registered. You actually don't own anything in that. It's a donation in exchange for a gift. So if you are making a public offering of stock on the open market, you have to have a registration statement. You must register that with the Securities and Exchange Commission. And there is a process. So you have to have, there's a pre-filing period, a waiting period, and then a post-effective period, which allows for the SEC and other regulatory bodies to evaluate your offerings. When we looked at what caused the what caused is almost each and every one of our big market crashes, depressions, recessions, things of that nature, we find this cyclical process where we have a lot of regulations that prevent some of the bad things that happened last time, and then people get frustrated with all the regulations, so then we have a deregulation period, and then it leads us into more bad conduct, which then leads us into some sort of great financial catastrophe. And then we start all over again, where we then come back to, oh, we need to regulate a whole lot. So then we start regulating a whole lot, and then people get frustrated. You see what I mean? So some penalties and violations that were put in the 1933 and that have been amended a couple of times include civil liability for false or misleading statements in your registration filing, in your annual statements. You cannot falsify information or mislead. You can also be held criminally liable for fraud. Also an important one. So as I mentioned, just some additional filings that came under the 1934 law. So periodic filings, quarterly reports, annual reports. If you have inaccuracies, stuff is going to get clawed back, and you have to have financial reports filed with the government. So some stock transactions that are going to constitute fraud and that are going to create an opportunity for criminal liability and civil liability. So 10B, section 10B, is a section within the 1934 Securities Act, Exchange Act, that prohibits certain behavior. So a corporation is not allowed to disseminate information in a way that is contrary to honesty within the market. There are safe harbor rules for dissemination of information that will give safe harbor, so to speak, for corporations that are releasing information. Some things that are prohibited: classic insider trading, misappropriation of information, people who aid and abet in either of those things, misappropriation of information or insider trading. Those are going to be violations, constitute market fraud, and then you can be tried civilly or criminally for violating that. Can't engage in short swing profits. So directors and officers and folks who own 10% or more shares cannot make a profit until 6 months after they purchase. If they do make a profit and then they sell it to make that profit, it's a short swing and they can get rake back. Sarbanes-Oxley requires that reporting stock transactions by the end of the second business day after the transaction is made. So you also can't hide that you did that. So some other amendments that happened, it created an administrative and criminal action scheme. People can also be sued civilly by individuals. It allows for whistleblower protections and then remedies for investors who are wronged by violations of the SEA. It also puts into play some of the things that we talked about earlier, like say on pay, proxy statements, remedies for violations of Section 14 and for 10B, things of that nature. So we talked last time, I think, about mergers and consolidations. So the SEC, the Securities and Exchange Commission, which was created out of the 1934 Act, will evaluate mergers, consolidations, and offers for purchase, so tender offers, to assess the legality of those things, right? The application of antitrust, but also to make sure that stockholders and shareholders have an opportunity to be heard about potential mergers, about potential consolidations, about offers for purchase, things of that nature. Some other kind of side regulations to think about and know about: state blue sky laws. So publicly traded corporations on the markets are a wholly federalized system. So your federal law acts as your floor and ceiling, so to speak. But some states have enacted state blue sky laws, which really act as like your sky to your ceiling. So they can be more intensive, more restrictive, and can allow for state remedies where there are also federal remedies. We have some uniform laws that apply to securities as well. Not shocking after all the times we've talked about them. And then just some like national improvement acts. Now, because the market engages in this cyclical, like, regulate, please deregulate, and then we crash cycle of self-harm, if you will. The industry has tried to engage in some self-regulation. So the Financial Industry Regulatory Authority was created to try and head off some of these problems. They will also participate in arbitration of the securities disputes. Arbitration is binding, and so that can sometimes prevent it from having to get to court. And then another way that the feds have decided to try to regulate other folks that engage in bad conduct in our open markets, which includes attorneys and accountants. The SEC will regulate third parties. So if you engage in fraudulent or negligent conduct as an attorney, an accountant, an auditor, you can be barred from working for a publicly traded corporation or for one of these regulatory agencies because of that. The Enron scandal was in part, large part, big part, supported in its occurrence by really shady, illegal accounting practices. Auditors knew about the conduct and did nothing to stop it. And so out of that, lawyers also participated in that too. Everybody hates lawyers, but accountants. So they all actively participated in that fraud. And so out of that came a lot of regulation and ways to hold those types of third parties civilly and criminally liable for participating in fraud. Mentioned this before, but other ways, right? So Sarbanes-Oxley was a big one about the executive compensation and clawback provision, the way that auditors participate in the preparation of financial information and the obligations that they have for publicly traded corporations to report that to SEC. And then you have the Private Securities Litigation Reform Act of 1995, which was really geared towards trying to prevent an abuse of derivative suits. which were kind of going bananas during the 1980s. And so another way to regulate third parties. And then, as I mentioned, those state securities laws. So, ladies and gentlemen, guys and gals, that is the end of our class. This is our last lecture. I hope you've enjoyed this content, and I look forward to seeing you during office hours or during our labs. Feel free to stop by and have a great rest of your day.